Hello, everyone.
Let me a minute.
Yes.
I will tell you 3, 2, 1. You are live.
Fantastic. Hello, everyone. This is Argyri Panezi. I'm an assistant professor at IE Law School in Madrid. So good afternoon from my side. This is going to be a short presentation in the context of the IP week of 2021, the IP Global Congress. Welcome also from my side. This has been a great program, so thank you to the organizers for the schedule and the organization for the entire week. Thank you to the viewers, our live viewers, and those who will listen to the presentation later. I will spend the next 10 minutes presenting so that I leave some time for questions if there are any, because the session will automatically close in 15 minutes. So I want to make sure that we go through everything. You're seeing my slides. This is, as you see, the basement of a library. This happens to be the New York Public Library. I will be discussing the case of emergency electronic access to library material. This is really a talk about a very recent and ongoing case before the US courts, before the courts of New York, Hachette v. Internet Archive, which started in the context of the pandemic. I wrote a recent paper on this topic, which is available online, the preprint on SSRN. And I'm really discussing the case to further discuss the need for copyright reform in view of the current litigation, and also a string of litigations against libraries over the past years, and the need to rethink electronic access in particular. Now, what happened in this case? You can see a timeline here. On the 17th of March, 2020, this is at the very beginning of the pandemic, when most places around the world were experiencing the crisis. We had emergency measures and shelter-in-place ordinances. So the American Library, we are situated in the US for this story, and the American Library Association announced at that point that libraries should close their physical premises in order to protect the health of the public and also their own workers. That happened on the 17th of March. Then, as you see on the slide, on the 24th of March, 2020, the Internet Archive, which is a non-for-profit library, online library based in San Francisco, and also famous for the creation of the Wayback Machine. They're archiving the internet for some decades now, announces that it creates this National Electronic Library Collection. That's what NEL on your screen stands for. Later, as you see on the 30th of March, explained the legal basis for the National Electronic Emergency Library, which had been the control digital lending system, a system that tries to replicate digital lending in real terms. So physical lending in digital contexts. Now, very quickly, we had reactions. We had reactions from the National Writers Union. We had reactions from the Association of the American Publishers, which basically are linked to this case. On the 1st of June of 2020, 4 publishers, the ones that you see on your screen, Hachette, John Wiley, Penguin, and HarperCollins, they all filed a copyright complaint against the Internet Archive before the U.S. District Court of the Southern District of New York. Immediately after, not immediately after, a few days after, on the 16th of June, 2020, the Internet Archive collection, the National Emergency Library Collection closed. The archives saw that there have been initiatives to remedy the immediate needs of the previous days for electronic access to library material and decided to close the emergency library. Now, what I would like to do very quickly over the next few minutes is to discuss what is the legal substance of this litigation. And of course, as you see in your screens, the case is ongoing. We're waiting for the parties to complete the factual depositions by the end of this year. And then by April 1st, the discovery will finish. Here, you see the announcement of the American Library Association explaining that the libraries will be closed during the pandemic. This is the emergency times, and that they should be responding creatively and proactively to the crisis, since they're not going to be able to help their patrons physically anymore. I have analyzed extensively the legal arguments for both sides in my article, and I also want to follow up on this as the case is ongoing. Very quickly, for the discussion to start here, I think that we need to focus on three main arguments if we want to talk about emergency electronic access in the context of this case, and generally speaking. The crisis of COVID-19 hopefully is not going to be repeated, but we do want to foresee what will happen if we don't have access to our physical libraries again, in view of future crisis, or linked to health or the environment or any other reason. The archive said that they moved very fast in internet time and are invoking a fair use defense, which I'm arguing that it might actually hold in view of the precedents of the Authors Archive v. Google cases and the Author Cathedra's cases. They're also invoking an educational use defense, that there is an urgent need for educators to have access and to provide access to educational material. This might need both parties to discuss the real market impact. And here we have another precedent, the Cambridge University Press v. Becker. And I guess that this might be a more detailed analysis of what is the exact market impact of this emergency library, which is where the court seems to be going at the moment. And third, the laches doctrine, that's the final point. The Internet Archive has said that the plaintiff unreasonably delayed the assertion of their rights, basically saying that they were not really after the National Emergency Library. What the plaintiffs, the publishers, wanted to complain about was the controlled digital lending program that has been in operation before the emergency. So my question here, and we will finish with that, is whether we are indeed looking at a case that brings about new market failures, or we are talking about old existing market failures. Have we thought about the way in which we access library material online systematically? This is something that I think was touched also in the very first presentation today. Or are we just seeing this in the context of the pandemic right now, but we're talking about a new market failure? What happened during the short period of time when everything closed and we just didn't know how to access books online? Copyright is not designed to react to a crisis. This is a very good case to see how can we incorporate crisis reaction within the context of copyright, perhaps within the fair use doctrine. And with that, I will thank everyone. That was a very quick overview. I look forward to any comments, and I'm available online on various social media and emails to discuss this further. Thank you.